Hello, I'm Jennifer Hollingsworth, a litigator in Nexen Pruitt's healthcare practice group. I often litigate disputes in the administrative law court, a forum that is unique in many ways from the other venues in which litigation occurs in South Carolina. The administrative law court, or ALC, falls under the executive branch of state government, as opposed to the judicial branch. Despite this distinction, our ALJs, or administrative law judges, are elected by the General Assembly just like the judges and justices of the circuit courts, family courts, and appellate courts. There are many benefits to having cases heard in the ALC. For starters, each case is assigned to a specific judge after filing, who then presides over the case from outset to end result. This continuity and identity eliminates the uncertainty experienced in the state judicial process, where a single case could have any number of presiding judges. Another tremendous benefit to appearing before the ALC is the experience the judges and their staff have in the specific subjects that are heard by the court, which is a result of the exclusiveness of the jurisdiction established by the General Assembly in the Administrative Procedures Act, or APA. The General Assembly established the ALC in order to ensure due process is afforded to persons that are aggrieved or upset with the decisions or actions of a state agency, of which there are many in South Carolina. There's an important distinction depending on the nature of the case you bring to the ALC as to what type of review takes place. In some cases, there is Denovo review of agency action, which means the matter is reviewed again with independent factual findings and legal conclusions made by the ALJ. And there's an appellate review for other administrative matters. I spend more of my time working on administrative challenges that involve Denovo review, which means my cases involve discovery, development of an evidentiary record, and a merits hearing with the presentation of witnesses and submission of documentary evidence before the ALJ. The presiding judge makes his or her own findings of fact and conclusions of law, not bound by the findings or conclusions of the state agency. This is the review process that applies to matters involving the Department of Health and Environmental Control, the Department of Revenue, and the Department of Natural Resources, for example. The other review process, which involves a closed record and a standard of review that is equivalent to that afforded by the Court of Appeals, applies to matters involving agencies that have an internal hearing forum, like, for example, the Department of Health and Human Services. Within HHS, there is a Division of Appeals and Hearings that provides for a hearing process and is the forum in which the evidentiary record is developed. If a person is aggrieved or upset with the outcome following the division's ruling, then the ALC hears the matter by reviewing the record created within the agency and considers legal arguments briefed by the litigants, evaluating whether the agency's decision was supported by substantial evidence. Other agencies that fall within this appellate framework are the Department of Employment and Workforce, the Department of Labor, Licensing and Regulation, and the Department of Social Services. Regardless of the nature of the grievance, Nexen Pruitt's lawyers stand ready to assist with your administrative challenge at the agency level, the ALC, or the appellate courts. Nexen Pruitt has served our clients for more than 75 years, and we look forward to serving you.